Well, here we are. The big story is coming your way this Thursday morning, and we have big, members from the different sides of Parliament to dilate on them, share their thoughts as we give you those big stories. Joining us as we talk about two crucial issues and beyond: the annulment of the BUEM parliamentary election from the 2020 elections, so that Santro Kofi, Akpafu, Lolobi, and Likpe can get representation. They say better late than never. And also the bit about the Supreme Court's ruling on the fact that a deputy speaker can vote. But what is the take of the minority? We get into these issues and more as we host Roxanne Nelson Dafeamekpor, Member of Parliament for South Dai. We also have Sylvester Tete, Member of Parliament, Botiano Englishi Amanfro. Gentlemen, a very good morning to you.
Good morning.
Good morning. Right.
And let me seize the opportunity to say good morning to my constituents. Peki, Kwali, Kweve, Tongo.
Okay. In the course of the discussion, we shall also be joined by Dr. Rashid Rahman, Executive Director, Africa Center for Parliamentary Affairs, who will join us on this conversation. Alrighty, let's start with this bit about the Supreme Court's ruling. Interesting dynamics in here. A deputy speaker of Parliament presiding over proceedings in the House has the right to vote on matters for determination. That is what the Supreme Court has ruled. Besides, the court held that a deputy speaker would also be counted as part of the quorum for decision making. We've seen some of the reactions, but before we get into those reactions, how do you react, Roxanne? How did this ruling, this decision of the Supreme Court hit you?
Yet, first of all, with due deference to the Supreme Court.
And you're speaking here as a lawyer.
Yes.
You're sounding very lawyer-like.
Loyally in the matter. And with due deference to them, I think they got it wrong.
Right.
This is a judicial coup against the legislature.
What did you just say?
Judicial coup.
I want to hear you
Judicial
very well.
coup.
This is a judicial what?
Coup d'etat.
A judicial coup d'etat. How does that even happen?
Against the legislature.
How does that even happen?
And I explained that. And I think it also amounts to an intrusion in the powers of Parliament, so to speak. It's a very sad interpretation that has come from the court yesterday. But I've been very shy from commenting vehemently on the matter because I'm waiting for the reasons. I'm told that the reasons will be given tomorrow.
The ratio.
Yes, will be given tomorrow. And so if we receive the full ruling, then we can deal with the grounds upon which the Supreme Court came to the interpretation that they came to. Yes.
What is your quick take on this, Honorable?
Well, thank you very much, and a very good morning to your good self and my brother Roxanne, and to the good people of Botiano English Aman from BNA. And I think this is clear, and just as it's struggling to attack it, it's obvious.
You mean Roxanne is?
Yes, I mean it's
struggling to rock the boat.
He can't rock the boat because in this case he knows 7-0.
Does that make a difference? Whether it's 4-3 or 7?
It makes a huge difference.
0.
You know why? If there's a dissenting view, then obviously the NDC or anybody who doesn't agree with them will have a reason the majority takes. It will not amount to anything though, but obviously you have a dissenting basis.
You have some straw to hold on.
Exactly. But you see, all the people, the worst of it is people criticizing it to the level as if they've even read the ratio. And I'm happy my senior colleague is saying that he's waiting for the reason behind the judgment.
Right.
And that is why I think we should all do. Student of law, student of parliamentary democracy, and all these, we should be interested in reading the ratio to come to a firm conclusion. But for people to quick to criticize it, and sadly, the minority leader, a respected minority leader, and a lawyer for that matter, he did not read it and to attempt to criticize it to the extent that is impugning a judicial coup over Parliament. I think that's quite unfortunate. And the worst of it all is a former flag bearer of the NDC. He's not a lawyer. I can pardon him. But I think that he is quite knowledgeable about the workings of parliamentary democracy, extremely experienced person, former president of the Republic, to attack the integrity of the judiciary to that extent. That's quite unfortunate.
Let me ask you something. I was talking about the relevance of a 7-0 decision, not because I do not know that it's reflective of the fact that there is a unanimity in there. But we've seen it in the election petition, 7-0, this 0, and all of that. And some people have become inured to all of that. Some people are also pushing back against this because they feel, Sylvester, that it appears for practically everything, anything from whatever level that you take to the courts, they feel the decision is only going to be one. In fact, I'm sure you're heavy on social media. You would see that people mock sometimes and say, oh, this one, it's a foregone conclusion because it's going to end a certain way. There's a certain trajectory. So when people see this time without number, and I'm putting it into context here, you know, you can call it famous or infamous, the words of Francis Xavier Sosu, Member of Parliament for Medina, who says, there are political judges who will be dealt with, supposedly, when their side comes to power, whenever that will be, politically. Then we have this incident where some suggest that this is Parliament. You don't cross the line. You don't tell us what to do. We are masters of our own rules. Where does that cease? Where does the Supreme Court now come and tell us, oh, this is black, but for some reason, we feel it should be white. And those are the issues. Are they not relevant?
You see, this book, this is the Constitution of the Republic of Ghana. And this is the rules or standing orders of Parliament.
Right.
This is subservient to this one. And the interpretation we are talking about is Article 104 of the Constitution. The Supreme Court, the original jurisdiction of the Supreme Court, is invoked to interpret the sections of the Constitution. Look, for me, Sosu, I'm happy the General Legal Council has called him before a disciplinary committee, of which he's a member.
Right.
I mean, I was so disappointed in his comments.
You cannot expect much in terms of justice. A cockroach cannot expect much in a court of fowls.
Look, he's just a sour loser. He's a lawyer. He's gone to court on many occasions. He's got judgment in his favor. Where were the political judges when he goes to court and win cases in the court? I mean, you cannot approbate and reprobate. Listen, whoever is presiding, the speaker, and I'm happy when that incident happened, and the deputy speaker ruled against a decision about a motion to investigate COVID-19
spending.
The Speaker of Parliament was trying to explain that he is the Speaker. You see, when he suits them, they may want to interpret it. And he says, look, Joe Wise is not the Speaker. So his ruling should stand.
But whether it suits them or not, is that not something you do? You do
no,
say,
please, don't say we shouldn't go. Please, easy, take it easy.
Let's get into that matter.
Yeah,
so are you disputing that you do say when it suits you?
No, but I don't understand what you mean we do say when it suits us.
I'm saying that in the politics of Parliament.
No, let me finish. But you are not even allowing me to
speaking for some time.
No.
He's making a point.
You're rebutting what?
He's making a point. You have ample opportunity to rebut.
Look,
thank you,
Roxanne, I mean, so for me, I think that it's quite unfortunate. Their criticism is their right to criticize. There's no two ways about that. The Supreme Court has spoken, and there's nothing anybody can do. This threat of we'll see on the floor of the House and all that is an empty threat. There's nothing they can do.
You're referencing what Sam George
Of course, I mean, it's just...
let me just, if I can...
you are not allowing me to flow.
He says... I'm
not flowing. You got the interjections are too many.
Go on.
Please. So these matter, the Supreme Court has spoken. And there's nothing anybody can do. You have a right to criticize it for whatever it is. We must all know that, look, however you view the Supreme Court judges, I'm not too sure the NDC, in an unlikely event, wins power. They will go chasing the Supreme Court. Look, that tells us the history of this country and how NDC and its antecedents have dealt with judges in this country. You remember the late chairman of the NDC, Kwabena Dufo, Kwabena J, Dr. Kwabena J,
Right.
killed the cat statement and all that. But I know that it will amount to nothing. Whatever they had, the Supreme Court has made a profound statement in this judgment. Now look, the Deputy Speaker or any member presiding, you see, people should know that in the absence of the first and second Deputy Speaker, any senior member could be elected among members of Parliament to preside over a matter in the House.
Right.
In such a situation, are you saying that the person ceases to represent his people in a matter of quorum or in a matter for a decision making or in a decision making, taking a decision itself?
Can I come in now?
You can.
There's a situation that the minority leader points out. The speaker is not available for whatever reason, whether he's in his office or he has something to do, but he's in the precincts of Parliament, or maybe he's not even within the precincts of Parliament. The second deputy is also caught up somewhere, maybe within the precincts with business. The first deputy is sitting on a matter. A vote is called. He is sitting as speaker. How does he move and vote, leave the seat vacant, and who will be chairing the proceedings at that point?
Listen, yes, that's a very good question to be asked. In a vote, and after taking the vote, they report to the speaker. So why? If you have to be counted, you could be counted, and the report given to the speaker. So it's not an issue. I'm not sure it's the speaker who goes on and count the people. The clerks do that. So the clerks will take the vote, take the speaker as well, and then hand over. So there's nothing wrong with that.
All right.
In any case, what they fought on the floor of the House, that they interchanged for him to take a vote and they resisted it. The interpretation has been given. And I'm saying on any occasion that the vote is taken, it's the clerks who count the people and give the report to the speaker.
Okay. Let me come to you on this. You have called this a judicial
Coup d'etat.
Coup d'etat.
Yeah.
Strong words.
Yes.
You're a man of the law as well. Yes. I mean, both of you know
I'm an officer of the court.
What it is. To use such words, you've chosen your words carefully.
Yes.
And yet you've used them.
Yes.
Why?
This is because the Supreme Court, as it were, has given a judicial blessing to chaos in Parliament.
Chaos?
Yes.
The Supreme Court has given a judicial blessing to chaos in Parliament.
It's a joke.
And I'll explain. Now, you see that this country chose for itself a certain parliamentary democracy. We didn't choose the Westminster type of democracy, where voting rights reside in the speakership. And one other thing that I think the Supreme Court got wrong is that they got the reasoning logically wrong. Because when we speak of the speakership, it is not about one person, it's an office. And there are occupants. There's a prefect, there are two deputies. So we have a speaker and two deputy speakers. And so by our own constitutional design and architecture, voting rights do not reside in the speakership. So when you are sent from the ordinary level of a member of Parliament to become a speaker or a presiding over proceedings in Parliament, you don't have voting rights. It's the same principle that we converted into our standing orders. And that is why, as part of our rules of debate under Order 90, the right to cast a vote or the right to speak to the matters on the floor. If as a speaker, you are, because you see, Parliament is a deliberative forum. You must have your say. Sometimes we just deliberate without even voting on a matter. So if as a speaker you don't have voting rights or speaking rights in terms of the matters on the floor. How can the Supreme Court interpret that to mean a deprivative of the right to speak and to vote? So they got the thinking logically wrong.
The justices of
yes,
the
they
Supreme
got
Court
the
thinking logically
wrong.
Right.
They got it legally wrong, and they got it jurisprudentially wrong. The jurisprudence underpinning a parliamentary democracy is one that the speakership has no voting rights. So you cannot be ascribing voting rights to occupants of the office of the speakership when the Constitution says no. And let me the speaker shall preside in parliament at all times, at all sittings. And in his absence, a deputy speaker shall preside.
A deputy
speaker. Please. No, a deputy speaker shall preside. 102. It says a quorum of parliament, apart from the person presiding. This is not me speaking. This is the Constitution. A quorum of parliament, apart from the person presiding, shall be wanted of all the members of parliament. Yes, I'll get to 104. When the Constitution gives a procedure as to how things be done, which is very clear, this is unambiguous, the Supreme Court could not be telling us a different thing. You cannot be counted for purposes of voting if you are presiding.
Right.
And I'm not limiting the presiding membership to even occupants of the speakership. Because the Constitution says in the absence of the occupants of the speakership, a member from amongst the members present will be elected to preside. In that scenario, the Constitution says you can't be factored into counting for purposes of quorum. Let's go to 104. 104 says, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. To a contract with the government shall declare its interest and shall not vote on any question relating to the contract. The Constitution gives a scenario where even a common member of Parliament could be denied the voting rights. The same Constitution prescribes circumstances under which the two deputy speakers could be deprived of their voting rights. So how does this amount to a final deprivation of voting rights or a perpetual deprivation of voting rights? Because there are circumstances that must be sprung to life. One is when you are in the chamber and the speaker is unavoidably absent. You must take over, and all the rights and privileges attached to the speakership will be attached to you.
Right.
Let me further say this. At the committee level, the chairmen of our committees do not have original votes.
Right.
Would the Supreme Court say that also amounts to a deprivation of vote? They cast a vote. So again,
but without a tie, they don't.
They don't.
Right.
So again, there are circumstances under which their voting rights are curtailed. So the interpretation for me doesn't.
So you say you're waiting for the ratio of the court, but
exactly.
But even before that, you have clear issues, and like you mentioned, you have problems with the logical, the coherence of the argument.
Because you see, logically speaking, the speaker does not participate in the debate. And to be able to participate in the debate, you should be able to have voting rights.
Let me quickly come to Sylvester on a few points. I know you'd have some rebuttals, and if we continue with the rebuttals, we'll never end. But I just want your take on this, considering what Sylvester. Consider Order 225. Which provides that, quote, the chairman of a committee shall not have an original vote, but in the event of an equality of votes, he shall give a casting vote. Can the Supreme Court declare the order unconstitutional because it deprives the chairman, therefore his constituents, of an original vote? I think not. Nor can the court, in my opinion, invalidate the casting vote because it makes the chairman a sole appellate judge of the committee's decisions. And I'll just skip to this point. Parliament and the courts are co-equal branches of government, and neither can tell the other how to run its affairs. Dafeamekpor. How do you respond?
Well, I think it's clear and that Parliament is a master of its own rules, but not to the extent that it becomes inconsistent.
Where has the inconsistency been? Is it because we have this new situation, the new context?
No. Constitution and placed verbatim in the standing orders of Parliament. There are many provisions that have been lifted verbatim and placed in the standing orders of Parliament.
So that defeats your point of inconsistency.
I'm coming. Where the interpretation becomes an issue. You see, one interesting thing is that the person who went to court did not go to court on the standing orders of Parliament. He went to court on the Constitution. And Professor Azar should know this. He went to court to seek the interpretation of the Constitution. I'm not too sure. The moment this provision in the Constitution has been lifted and placed in the standing orders, it ceases to exist in the Constitution. It doesn't.
So you feel
so the original jurisdiction.
If Justice Abdullahi had gone
gone
on the standing orders, it would have made any difference.
Yes. The interpretation ought to be purposeful.
Oh, please, that one is your thinking.
You are not clothed.
You are not clothed.
But don't you think he went? Hold on, Roxanne. Let him. But don't you think he went on the back of the Constitution? Because, like you're pointing to, I mean, even if he went on the standing orders and maybe a decision were arrived at, you know that at the end of it, this is the mother of everything. Yes. The 1992 Constitution. So it's logically correct.
The standing orders
and I've quoted the Constitution.
The standing orders of Parliament were borrowed. These provisions were borrowed from the Constitution.
But why not go to the source document?
But the source document is a Constitution.
Yes, exactly what I'm saying.
So I have quoted the Constitution.
Roxanne,
the word you've quoted, you have admitted that you have not read the ratio. The people clothed with the authority to interpret it. It's not you. And it's not how you feel. It is about the institution with all given authority to interpret it.
They got it wrong.
Well, you can criticize.
And I want you to stop saying that they have spoken and there's nothing anybody can do.
I don't want too many interjections.
Please.
Sylvester, also, just calm down.
No.
I don't want too many interjections.
Yeah.
I want him to flow and make his point. Roxanne, I beg of you. Go ahead.
Please. Why are you so... Look, please. The point is that I'm saying that they've spoken. You can only go for a review of that decision, which I don't see. 7-0. You go, they add 2. You have 9-2. Assuming it goes your way, there's nothing you can do. Look, we must be believed to chaos. Let me tell the NDC.
No. What I said was they have given a judicial blessing to chaos in Parliament. Yes.
Well,
because this
it's okay.
You've clarified.
Yes, you've clarified. But after today, that the Supreme Court has spoken, any attempt to resist that in Parliament means you are flouting the authority of the Supreme Court. That is why I say you can't do anything about it. Only option available to you.
I think you should stop using that.
I'm saying you can't do anything. You can't do anything.
Stop.
They should stop threatening the democratic process in this country. There's nothing they can do. You can't do anything.
Sam George says, "Abi we all good day the chamber." Hold on. Abi we all good day the chamber inside. Come and give the referee the ball to play some. Let us see. The sweetness of the pudding is in its eating. Of course,
it's a joke. It's a joke.
Sam George
is a joke.
He's a joke.
It's a joke. With this, is a joke. Please.
They have said
Sam is my brother.
Sam was here yesterday.
I don't mind. So please,
hold on.
It gives people the impression that you are receiving support. Yes, it gives people the
made a determination, an interpretation of a provision of a constitution. Please.
They are saying, and it's important. There's a reason I'm hammering this. No, hold on.
Please, let's not
trivialize. Let's not trivialize this. Let me tell you, as we have this discussion.
For you to have read this even on air, is an attempt to undermine the authority of the Supreme Court.
What I say.
No such.
What I say.
And I think
has the Supreme Court judges been bastardizing
member of Parliament, your own colleague member of Parliament.
What are you talking about?
By reading it, I
am saying that. Listen.
No. I think
where does this go?
I don't think that was a fair.
No, you see, we are building a society, and we don't build a society with this kind of comment. When the Supreme Court of the land had made a determination of a case, the option available to you is a review. You don't go by...
That is not the only option.
But you see, I've said that...
I have an option of criticism.
You can criticize. I've admitted that.
That's what we are doing.
That's exactly what they're doing.
That's what we are doing.
This is not what he's threatening.
He's not threatening.
Read what he posted.
He's not threatening.
Please.
He's not threatening.
My brother.
Look,
my brother.
You sit here, you organize...
Let him have his turn.
You think Ria Koto was determined by people in Mokola?
If we continue like this, I may have to mute your microphone.
You see,
just hold it for me.
I had admitted from the beginning of this discussion that they have a right to criticize it. Nobody can take away your right to criticize the Supreme Court ruling. But I'm saying, for you to say the sweetness of the podo is in the eating, and therefore, if they come to the floor, they should attempt to make the referee vote. What are you saying? That becomes a threat. But ability to criticize or the right to criticize are admitted. They can criticize, hold forums, lectures. Look, when the 2012 Supreme Court ruling was delivered, we had lawyers organizing forums to criticize it. And it's so right in the eyes of democracy. There's nothing wrong with that. But this kind of commentary, it doesn't help to build the institutions of state. That's the point.
So when Professor Kweku Asare,
he criticized it,
who is, very learned,
yes,
and speaks on legal matters, rights, Parliament and the courts are co-equal branches of government, and neither can tell the other how to run its affairs, and goes on to say, if you'll indulge me, not take part in debates, vote, or should not caucus with his party on a matter pending while he presides. It is not for any court to inquire into it, just as it is not for Parliament to inquire into how justices are chosen to sit on cases at the Supreme Court, or that is impaneling, or why some cases are disposed of with expediency and others seem to disappear into oblivion.
I agree. Look, please.
You see, I have to.
Time. Why are you doing this?
Allow someone to dilate on the issues properly, else it will be a plot of, we'll just be going
I've said that it's part of the criticism of the ruling.
No, but is there any reason in this? I mean, when you listen to it,
no, but
is it rational?
Yes, you have listened to his reasoning for saying so. And I'm saying that you haven't even read the reasoning of the Supreme Court judges. But listen, like I said, those who went to court did not go to court on the orders or the standing orders of Parliament. They went to court seeking an interpretation of the Constitution. And that is the precept of the Supreme Court.
Right.
Dr. Asare failed to avert his mind to that. And I will call him to pick his thought on that one.
Right.
So you see, it is not for nothing that those who went to court did not go to court on the standing orders of Parliament. They went to court on the orders of the Supreme Court, the Constitution. And Parliament cannot. So if today Parliament amend its own standing orders and separate provision devoid from any provision from the Constitution, perhaps that will suffice.
All right.
But so long as it remains the provision of the Constitution, the Supreme Court has original jurisdiction to interpret it, and that's what they've done.
2 minutes, Roxanne.
Yes. Quickly, one, it cannot be said. It cannot be said that Professor Asare, in writing this brief opinion on the matter, didn't avert his mind to the fact that the Supreme Court has the power to interpret the Constitution.
But listen,
I think
if you're saying that the justices could have missed a few things, it is possible for Professor Kweku Asare to also miss a few things.
Well, but
we are all human.
But I think that you averted his mind. If from what you've read,
the justices, all 7 of them could have missed
yes,
and it is possible for Professor Kweku Asare to also have missed a few things.
2, in Article 110 of the Constitution, provisions of this Constitution, Parliament may, by standing orders, regulate its own procedure, subject to the provisions of this Constitution. How is it determined that the provisions in the standing orders run contrary to the provisions of the Constitution when it was lifted verbatim? How is that possible? How is it possible that, for instance, you can say...
Which goes back to Sylvester's point, because this was lifted verbatim, directly.
And I'm saying that how is it possible that you can interpret the Constitution to say that, for instance, our Order 90,
right,
it's inconsistent with the Constitution, so it should be shut down. That, I don't know whether that has been touched on. We say that the Speaker... You see, there's a certain parliamentary jurisprudence that ought to guide any interpretative exercise in respect of the Constitution regarding parliamentary work. Look, it is not for nothing that the speaker is the one who determines who speaks on the floor. It's not for nothing that it is the speaker that puts the question.
Right.
Those are rights and duties ascribed to the office of the office holder or speakership. So, when certain practices, and I want to quote Oliver Wendell Holmes here, one of the greatest legal minds I ever worked on planet Earth.
Oliver Wendell Holmes,
Yes.
right.
That the life of the law has not been logic. It's been experience. Parliamentary procedures and practices have been time-tested. We may not do things as done in other institutions, but there are certain procedures that have been time-tested and served. In our democracy, we have stated clearly that the speaker and his two deputies will have voting rights. You will not be counted when we are determining quorum. And you will not have voting rights when you are sitting. So I like.
Well, let's wait for the ratio and
so,
see whether.
So like I said, I am waiting for the reasons. Then we can all.
When the ratio comes, then we'll see.
But don't let it be said that a Supreme Court decision cannot be questioned. In fact, judges question their own colleagues.
In fact, since we have judicial review,
Exactly.
I mean, you can't even say that is.
And let me make the point
Right.
that I have seen chief justices, I have seen Supreme Court judges go to a Ria Koto lecture and bastardize decision of another Supreme Court in the 60s. Ria Koto decision was a decision from a Supreme Court, Ghana's own Supreme Court.
Right.
But you have Supreme Court judges bastardizing that decision.
Landmark decision.
Thank you. So don't let anybody say.
Let's take a quick look at this.
That we can't criticize the court.
And I'll reference you. There's a reason.
no.
There's a reason I was citing what Sam George mentioned. Two things. Yesterday, Sam George was here, sitting right there, and he said that between now and 2025, there will be no agreement between you guys in Parliament, your side and his side. And a lot of people, reacted to that. Tie that into a message that Enoch Njirbi sends. He says, please, how much are the tickets to watch parliamentary proceedings? I can't miss the game on e-levy day because this person supposedly is anticipating a brawl in Parliament. Of course, no need for tickets. You can, even as a... that is the context.
No, I think now the gallery...
The hard stances that have been taken, where the NDC, even on the back of this ruling, is saying, Yena Yanshe. And you guys are saying, this is how we're going to do it. Hopefully, we forestall any chaotic incidents in Parliament.
See, this ruling of the Supreme Court should not be viewed to be solely for this 8th Parliament.
It's a problematic ruling.
You see, if you view it to be for this 8th Parliament because of the peculiar nature of the 8th Parliament, you are getting it wrong. It is not. It is something that until the Supreme Court depart from its own ruling, and of course, let me also place on record that the Supreme Court itself can depart from its earlier rulings. And it's been part of our judicial
our judicial narrative.
Narrative in this country. So there's nothing wrong for a Supreme Court to depart from. So until then, that is the position of the law.
All right.
So for me, when people begin to view this as MPP or the majority side today, then we are missing it. It is
for those who say
so
that
let me come to Sam
the
George's.
judiciary is okay. You go to Sam George.
So for Sam George to say, you may not be happy with the ruling, you can criticize it, you can bastardize it.
No, he didn't react to the ruling.
Yeah,
the bit I spoke about, there
Yes.
will be no consensus, has nothing.
Yeah, but I mean, well, if there's, I mean,
It was before.
I mean, he knows.
He says you guys are hypocritical because you are not honest. You engage in underhand.
I'm not sure we are set to discuss other.
They will not agree with you on it.
Look, there are so many things we had agreed on just recently about this Sputnik V investigations
and those rather petty matters.
Yes, so for me, I think that we've agreed on many issues from committee level. Report of committee, go back and take the records. And he's been part of it. Look, he's a deputy ranking and I'm a vice chairman of the same committee, communications committee. We've agreed on so many matters and we are still working.
Right.
So for him to say that, I don't know whether he's going to change his position, because we've been clear on matters at the committee level. And we've worked together, and we're still working together. So for that one, there's nothing to do with this. But let me say, finally, on this ruling, that people should not view this ruling as a victory for MPP or for 8th Parliament. It meant to help shape or develop our parliamentary democracy and practice in this country.
Point made. Point made. Let's move the discussion forward. No. No more on this discussion. No, I will not allow.
Let me say this.
No.
Let me say 30 seconds.
No.
I would have been done. I would have been done.
You are done.
Look, the interpretation is problematic because do we view the first deputy speaker, for instance, as speaker for Bekwai or speaker of parliament? When he's been told that he has voting rights. And what is interesting is that...
That's interesting.
Yes.
Speaker for Bekwai or...
Yes, because you see, the man has been speaking similarly a couple of days before yesterday. In very familiar tones.
30 seconds is over.
What are you suggesting? Just to wrap. What are you suggesting?
It's interesting that the things he said over the weekend is what the Supreme Court decided on yesterday.
Come on.
Wait. Roxanne Nelson,
Yes.
Dafeamekpor.
It's interesting.
I am trying to get a megaphone to hear you.
Yes.
Are you suggesting to me?
Because you see,
hold on.
hold on. When the matter is sub judice,
Hold it.
you don't go speaking about it, especially...
So it's sub judice and he has shared his thoughts.
Yes, shared his thoughts.
And the Supreme Court rules.
He was emphatic.
And you say because what they say is familiar.
Go and read. He says he will vote anytime he presides. When he knew that was the gravamen of the matter before the Supreme Court. Just this weekend.
Are you suggesting his saying
on what basis was this? On what basis?
I'm asking you a pointed question. You're a lawyer.
No, yes, I'm a lawyer.
That Osei, not Osei Chimensabonsu, Joseph Osei Wusu,
Speaker for Bekwai.
Comments.
Speaker for Bekwai.
Comments influenced the Supreme Court's decision.
I am saying it is interesting. I'm saying that it is very interesting that he was very emphatic in the outcome of the decision.
Okay,
and it's a problem for us.
Let's move this conversation forward. If we stay here, we'll never end.